we are, I believe, recording the meeting, right? And it's a great pleasure and honor for me to welcome Professor Zoltán Szente as the next lecturer as part of the lecture series devoted to constitutional polycrisis and emergency constitutionalism. My name is Martin Belov. I'm professor in constitutional and comparative constitutional law at the University of Sofia Faculty of Law. And I am also leader of one of the strands of the project called European Values and Social Challenges, EU-VASC, which is funded by the European Recovery and Resilience Fund and the University of Sofia. So in the framework of this project, we are organizing several groups of events. I'm organizing 3 big conferences. 2 of them already took place in the spring and in the autumn of 2024. And the next one is forthcoming. It will take place on 4th of April, and will be devoted to constitutional polycrisis and emergency constitutionalism. Apart from that, I'm organizing 2 strands of lecture series. One of them is devoted to constitutional imaginaries, and the next one, which is actually related to the lecture today, concerns constitutional polycrisis and emergency constitutionalism. And also, I'm organizing several publications. One of them was published with the Review of Central and East European Law, peer-reviewed and indexed journal published by Brill. And I had the pleasure of inviting several leading colleagues from Europe to publish their papers as part of this volume devoted to the constitutional transitions and traditions in Europe, in Central and Eastern Europe. One of them is Professor Zoltán Szente. So we have published these 8 papers. The journal is available. This special issue is available online. Some of the chapters are open access. So if you're interested, you can take a look at them on the webpage of the Review of Central and East European Law. Professor Szente actually published there a paper devoted to constitutional imaginaries. But since we are participating with him also in a very fascinating and interesting Swedish project, so we are going to meet in Lund in March, and we're going to talk about the role of court. I'm grateful to Mrs. Asenia Dimitrova, who just shared the link to that special issue of the journal in the chat. So if you're interested, you can just click. If you want to click, do it right now, because after we end the lecture, the link will disappear. So anyway, what I want to say is that Zoltán will talk about the topic of the role of courts in emergencies soon as well. And since this is a very important topic, it relates to both the new role of courts in the last 20-30 years that they gained in the context of that shift towards a model beyond traditional understanding of representation and representative democracy. And also, since the topic is related to the unfortunately ever-present issue of crisis and emergency, I think this lecture is, again, unfortunately, kind of permanently important, but also currently topical, since we are living in what I would define as constitutional polycrisis, financial migration, pandemic, technology-related. And it is really important to see what is the appropriate function, role, position of the courts in managing situations which are usually related to sovereign power, namely the emergencies. Few words about Professor Szente. He is one of the most renowned scholars in Central and Eastern Europe. He is professor in, and has been professor, and is professor in several Hungarian universities, including Eötvös Loránd. He was also Fernand Braudel Fellow at the European University Institute. And he's well known in working in cutting-edge topics related to constitutional and comparative constitutional law. So without much ado, I have spoken for only 6 minutes, which is a record for me. I'm giving the floor to Professor Szente. He'll have 45, 50 minutes, 1 hour, and then, of course, you can raise your physical or digital hand and ask the questions which you want to pose to Zoltán. So Zoltán, the floor is yours.
Thank you. Thank you, Martin. First of all, I would like to thank you for inviting me to this event and to the project. And I'm really pleased to talk about the role of courts in emergencies. And thank you for introducing me. I'm now the research professor at the Institute for Legal Studies, Center for Social Sciences, and as Professor Belov referred to it, in the last academic year, I was a senior fellow of the European University Institute in Florence, where my research topic was the rule of law requirements of emergency. That is, my task was to identify and justify those constitutional values and rule of law values which cannot be waived even in times of emergency. That is the core values of the rule of law. Now I lead an international research project on constitutional risk management in Visegrad 4 countries, which is a comparative research of emergency law in the Czech Republic, Hungary, Poland, and Slovakia. Then I also lead another international project which examine how the methods of constitutional interpretation change in emergencies. I think that it is undoubtful that in the protection of core values of the rule of law, courts must have an eminent role. But what is this role? What is the legitimate scope of judicial intervention in constitutional crisis management? That is the question, a very basic question, and that is the subject matter of my presentation today. Now you can see here the structure of my presentation. Firstly, I will talk about this very basic problem, and I will try to define some basic concepts of the topic. After that, I will describe you quite briefly the major and essential legal theories of emergencies, concentrating only on two very basic and rival theories of state of emergency. Then you can hear some examples, some quite famous landmark decisions, very essential judicial decisions from all over the world, if you like. Then the core problem, I will try to explain the most important pros and cons of the role of judges in emergencies. That is, how to measure the extent of judicial intervention in political decision making in times of emergencies. And finally, I will outline, or I will try to outline, some possible standards of judicial review of emergency measures. So that is the structure of my today presentation very shortly. So first, let me start my presentation by saying that emergency law is in a special situation, both in legal systems and in jurisprudence, that is, in legal science. On the one hand, according to one important theoretical school, emergencies are inherently extra-legal phenomena. That is, which means that emergencies or emergency situations cannot be regulated, cannot be interpreted by law. So that is quite unique situation, in particular in legal discourse. And on the other hand, even if emergency situations can be regulated by law, they are at the crossroads of several different areas and branches of law. Nevertheless, due to the social sentiments that we are constantly living in a state of danger because of the successive global and regional crises, as Professor Belov referred to it, and due to the corresponding policy and lawmaking of the governments, emergencies have become gradually the focus of interest within jurisprudence as well. global crises such as the new wave of international terrorism, global economic crisis, mass migration, the COVID-19 pandemic, Russian-Ukrainian war, and looming threats like global warming or the energy crisis pose a serious challenge to the traditional institutions and functioning of constitutional democracies in general, and to the constitutional and judicial review in special terms. I said that this challenge is serious for two reasons. First, because executive branch usually is granted with exceptional power. In such circumstances, the government has such a great power which otherwise could be completely unacceptable in normal circumstances. For example, fundamental rights may be restricted to a much greater extent than usual. State intervention may be more extensive than in normal cases. So it would be quite logical to conclude that expanded power requires stronger judicial control in order to avoid the abuse of this extended power. However, averting threats usually requires very rapid response and action, and only the government is in a position to do that, that is to effectively manage crisis situations. So this fact can very easily overshadow the role, the traditional role of the judiciary in emergency situations. So in other words, the very basic dilemma or fundamental dilemma is the extent of judicial control over the exceptional power exercised by the executive branch based on constitutional authorization, when only the executive power possesses relevant and sufficient information and expertise to overcome these or to overcome the crisis. In normal case, anyway, it is not a question that the exercise of legislative and executive power must be checked by courts. But does it have to be like this, or can it be like this in an emergency situation as well? So that's the core question. So that's the problem, and that's the question which needs an answer. However, it is important to note that there is no universally valid answer to this question, or there is no, let's say, an authoritative or authentic answer to this problem, but it is really a widely discussed problem in academic discourse, legal discourse. What you can learn, hopefully, from this presentation is the most important and information and arguments needed for this discourse. As to the basic concepts, emergency means serious threats of the state or society, and they're particularly protected values by a direct risk or an existing crisis that has already occurred. Constitutional order, life, health, and property of citizens can be such basically very basic constitutional values which should be protected in times of threat. While the threat must be, and it's essential, so this external or internal threat should be so serious and immediate that it cannot be by the normal means of public authorities. So that's the reason for granting the executive power expanded or exceptional power. State of emergency means a special legal order granting this kind of exceptional power to the government or any other special organ of the executive power in order to prevent the threat and eliminate the harmful consequences of the emergency. From a legal point of view, it is an indispensable requirement that its objective, that is the objective of granting this extended power, is nothing else than to restore the normal constitutional or legal order. In this context, courts are those judicial bodies which have jurisdiction to make legal decisions regarding the constitutionality or legality of individual or emergency acts, namely constitutional courts for adjudicating the constitutionality of emergency acts, I mean normative acts, that is legal acts, administrative courts reviewing the legality of normative and or individual administrative measures and decisions taken by public authorities during emergency. And finally, this concept covers ordinary or common courts deciding legal disputes in individual cases. So if we can move towards to the major legal theories of emergencies, one of the fundamental questions of the legal science research on emergencies is whether it is even possible to legally conceptualize those extraordinary situations that may justify the introduction of a special legal order and its authorization for an extended power of the executive branch that may justify the introduction of this special legal order in order to avert the imminent danger. Indeed, even today, there's a widespread and contested conceptualization of it in legal theory, which places such special situations, these kinds of extraordinary situations, in the extra-legal sphere. This is the so-called Schmittian, named after Carl Schmitt, a German legal philosopher in the interwar period, in the first part of the 20th century. And today it is frequently called neo-Schmittian concept. There is Schmittian conception of the state of emergency, according to which it is a category outside the domain of law, creating a legal black hole. That is a situation that cannot be interpreted by legal tools, and in relation to which the law can only determine that who is the so-called sovereign, who can act, but anyway his or her power is completely unlimited. The precise details of an emergency cannot be anticipated, says Schmitt, nor can one spell out what may take place in such a case, especially when it is truly a matter of extreme emergency and of how it is to be eliminated. The precondition, as well as the content of jurisdictional competence in such a case, must necessarily be unlimited. The most guidance the Constitution can provide is to indicate who can act in such a case, says Schmitt. Today, the proponents of the so-called extra-legal measures model of emergency powers think that in times of emergency, public officials who are anyway in charge of managing those emergencies can or should be able to use extra-legal powers if necessary, although they must be held responsible for the methods they use, but just afterwards, that is, after the end of the emergency situation. So this position is ultimately based on the argument that since dangers or threats cannot be foreseen, it cannot be seen before or calculated in advance, the way to avert them cannot be determined in advance either. So that's the very basic reason to give them unlimited power, because they are, I mean, the executive branch or executive power can be able alone to see what are the really needed or necessary means or instruments to overcome the threat. So furthermore, it is possible that the danger is so serious that it can only be managed by, so let's say, extra-legal means. The other main school of thought understands emergencies very much within the legal systems and sees them primarily as a legal institution, or at least legally a situation which can be regulated or handled or managed by legal instruments. According to such, let's say, legal positivist approaches, it is not a very exact category anyway, views emergencies and exceptional powers are in need of legal regulation, as they in themselves pose a significant threat to democracy and the rule of law. A situation in which the executive, elected or not, can simply declare a state of emergency on the basis of its own judgment and lay down and take the emergency measures involved without being subject to adjudicative challenge is certainly incompatible with democratic government, according to a famous thinker of this kind of school. So this dichotomy is often characterized as post-Madisonian or post-Schmittian conceptions or approaches. So beyond these, a number of theories and analytical frameworks have been elaborated for explaining the legal nature of emergencies or proposing doctrinal mindset for managing state crises, such as the so-called fiduciary or reason of state theory, public interest theory, and many, many other theories of emergency constitutionalism, but discussing them is far beyond the scope of my presentation today. In fact, these approaches have had a significant impact on the discourse on emergencies, which has become particularly intense in the last 2 decades. Martin referred to that, due to certain events and new phenomena. For example, these mainstream theoretical models were developed or at least revived in the aftermath of the terrorist attacks in the USA, 2001, in the context of the war on terror, and after the terrorist attacks in Paris, London, Madrid, and other major European cities, focusing primarily on defending against violent attacks on states, while the early 2020s saw a lively scholarly debate in the wake of the COVID-19 pandemic. So I would say that following the terrorist attacks in the United States in the very early 2000s, and in several major European cities in the early 2000s, emergencies became a focus of legal research and legal discourse. This has also meant a major paradigm shift, as previously the special legal order had primarily been equivalent to martial law applied to war and other international armed conflicts, whereas now the focus has shifted to the legal management of internal security risks. In fact, these events restructured the discussions about state of emergency, as the discourse generated started from the assumption of dangers that threatened to destroy the whole state structure and the constitutional order as a whole. So as a result, scientific works focus on finding a balance between security and freedom, but this was also the reason why the specific approach of legal theory came to the fore, which consider emergency situations of this type unmanageable by law. Somewhat surprisingly, Hurricane Katrina in 2005 in the USA, or the Fukushima nuclear accident in 2011 in Japan didn't generate a similarly lively scientific discourse, probably because, however severe they were natural or man-made disasters, their impact was isolated in the sense that they didn't bring about such a danger as to which traditional martial law could be the answer. Only, maybe I'm wrong, but I believe that only the COVID-19 pandemic and more indirectly the increasingly obvious climate change directed more attention to the management of crisis caused by nonviolence, that is, on natural disasters. The pandemic unavoidably retested the functioning and effectiveness of emergency regulations that is the earlier or existing emergency regulations of national legal systems. This was a real novelty in that the exigencies were no longer caused by some internal or external act of violence, but a natural phenomenon, and moreover, at the same time, almost on the entire globe. However, the traditional emergency rules were either not applied to such risks, or if they were, there was no experience in this regard either. In addition, this time, it was not just that the states had to face a new kind of emergency, but from mass migration to climate change, more and more crises are emerging that the normal legal order doesn't seem suitable or sufficient to deal with. So far, all this hasn't brought about significant paradigm shift in emergency studies. Scientific discourse looks to the legal management of emergency situations as an inalienable sovereignty issue, or alternatively as a possible European Union policy in the far future. Okay. So if we are approaching the question of the legitimate role of courts and judges in a state of emergency, that is the scope of judicial review of emergency measures, including normative or individual legal acts, it can be useful to take a look at some very well-known judicial decisions to illustrate how different approaches were used by some courts when deciding on the legality of various emergency measures. In fact, though these landmark cases demonstrate, I would say, a whole scale of possible solutions regarding the scope of judicial review. The first case is a historical one that's from the 19th century, so-called ex parte Milligan case. During the American Civil War, President Abraham Lincoln, President of the United States of that time, declared martial law in 1864, sanctioning arbitrary arrest and detention, suspending the writ of habeas corpus, that is personal freedom, and establishing, that is setting up so-called military commissions. In other words, military tribunals against civilians. After that, such a military commission convicted an American citizen named Landon Milligan for treason to be hanged, that is to be executed for treason. Milligan, you can say his picture, Milligan challenged the sentence and turned to civilian courts. And the case solely reached the Supreme Court of the United States. The court found eventually that the use of military tribunals in cases of civilians was unconstitutional when, anyway, ordinary courts are still operating. So in such a case, military tribunals cannot make any sentence against civilians. The court said that the Constitution of the United States is a law for the rulers and people, equally in war and in peace, and covers with the shield of its protection all classes of men at all times and under all circumstances. The government within the Constitution has all the powers granted to it which are necessary to preserve its existence. the philosophy behind this decision is actually that there is no need for a state of emergency at all, because the government has all the tools it needs to be able to combat any threat. I must say that today or nowadays, this is an outmoded or old-fashioned approach. So because most legal systems recognize the necessity of exceptional power in case of emergency and to establish a special legal order in case of imminent threat. So therefore let me move to another very famous historical precedent, which can illustrate the judicial deference in emergence as in relation to the judicial review of emergency measures. That is the very famous case of Korematsu versus United States from the time of the Second World War, from 1944. It was a landmark decision by the Supreme Court of the United States that upheld the internment of Japanese Americans, that is, American citizens of Japanese origins, in the USA from the West Coast military area during World War II. After that, Japan attacked the United States in a Second World War, Pearl Harbor, a naval base and headquarters of the US Pacific Fleet in December 1941. President Franklin Delano Roosevelt had issued an executive order on February next year, authorizing the US War Department to create so-called military areas from which any or all Americans might be excluded. On the basis of this executive order, the US Army issued another more particular military command, according to which all persons of Japanese ancestry, including aliens and non-aliens, to relocate to internment camps. However, a 23-year-old Japanese American man named Fred Korematsu refused to leave the exclusion zone, and therefore he was convicted by a court. He challenged the constitutionality of this judicial decision on the grounds that it violated a constitutional provision, of the Constitution, not the Constitution, the Fifth Amendment to the US Constitution. So in fact, it was a precautionary measure. I mean, that is, the internment was a precautionary measure, presuming that Japanese who live in the USA are potential spies, even though they are anyway, or they were average US citizens. So the Supreme Court showed a deference to the military authorities during an emergency because of war, accepting that this measure was necessary because even though a number of citizens of Japanese descent, there could be some disloyal people among them. Not all of them, but some of them could be really spies or could be disloyal to the constitutional order of the United States. So it was only passed by a narrow majority, 5-4, and in the Supreme Court, and practically it was reversed in 2018. Conviction was overturned anyway against Korematsu already in 1983. So in this case, the court actually didn't review whether the emergency measure that is severely restricted fundamental rights was necessary and proportional, but took the position, a deferential position, that only the army itself could decide what measures were necessary to avert the danger in that specific situation. If we can move toward, oh, sorry, the other. Uh-oh. Yeah, The next case, that's landmark case, can demonstrate let's say, an intermediate position between judicial deference and judicial activism. It is also a very well-known case from Britain, that is A and others, where the Secretary of State for the Home Department, the so-called Belmarsh case. Belmarsh is a famous prison in Britain. In 2004, in Britain, 9 individuals were detained under a relatively new act, an act on Anti-Terrorism, Crime and Security Act of 2001, on the basis that there was some evidence that they posed a national security threat. So they were threatened with deportation without trial. So that's the point, that the detention without, sorry, not detention, detention and deportation without trial. A provision of this act enabled the individuals to be held indefinitely without trial or deportation, so under custody. It is important that this law was applied only to non-British citizens or nationals. 9 people who were deported on the basis of this new legislation. 9 people turned to court claiming that the procedure violated the European Convention on Human Rights. The House of Lords, at that time, the House of Lords was the highest judicial body in Britain. Since then, there has been a High Court or Supreme Court, sorry, in Britain. But at that time, still the House of Lords was the highest judicial tribunal in that country, and the House of Lords had that provisions under which the applicants were being held at Belmarsh prison were incompatible with the European Convention of Human Rights, which strictly prohibits such kind of treatment of people. These judgments shows an intermediate position, a transition between judicial deference and activism, because while the highest judicial body was willing to check the exercise of the executive power, even in case concerning national security, which is quite serious case, and why it declared also that the more purely political, in a broad or narrow sense, a question is, the more purely political a question is, the more appropriate it will be for political resolution, and less likely it is to be an appropriate matter for judicial decision. It is the function of political and not judicial bodies to resolve political questions. It is to be added that the judgment did it, quote ends. So it is to be added that the judgment didn't bind the Home Secretary and didn't seize the detention of the applicants. Therefore, this decision was an intermediate position, in a sense that while the court undertook to make a decision to say that it's not okay, this deportation without trial was against the European Convention on Human Rights, but still it was not able, or it didn't want to provide or give real judicial protection of those people who were treated in that way. Notably, anyway, a little bit later, the case reached the European Court of Human Rights, that is the Strasbourg Court, which said that in its judgment in 2009 that the indefinite detention of non-nationals who are suspected of international terrorism-related activities breaches the European Convention of Human Rights, and the British measure made an unjustified discrimination between nationals and non-nationals. So there were some examples of, let's say, judicial activism even in times of emergency. You can see here an example for that. Let's say judicial activism, another very famous judicial case from constitutional history, Indira Nehru Gandhi versus Raj Narayan from 1975. The case, anyway, was a part of a long political struggle in India, and the judicial review of the declaration of national emergency of those days was only a, let's say, a side event in this political battle or in the whole story. Still, it is a good example of judicial activism in emergency cases. In 1975, the High Court of Allahabad is a great city in Uttar Pradesh. Uttar Pradesh is a federated state in India. So the Court of Allahabad annulled the election of Indira Gandhi as prime minister of the day on the grounds that she was involved in unfair practices or behavior in election process. During the legal battle, a state of emergency was issued. So at the initiation of Indira Gandhi, and a constitutional amendment was passed during that emergency situation, stating that the election of the prime minister may not be legally challenged in any Indian court. So the obvious objective of this constitutional amendment was to prevent Indian Supreme Court from dealing with this case. However, the Indian Supreme Court confirmed its earlier practice, declaring that Parliament doesn't have an unlimited power to make amendments which changes the basic structure of the Indian Constitution. So eventually, neither a constitutional amendment nor the state of emergency was not sufficient to prevent the Supreme Court from protecting the basic structure of the Indian constitutional values of the Indian Constitution. So I would say that is very good illustration for judicial activism in this era. So over time, as more and more was learned about the effects of the COVID-19 pandemic, more and more constitutional court and administrative courts, for example, over the world or particularly in Europe, have stated that only threats based on reasonable and specific evidence can justify restrictions on fundamental rights. Okay, but however different international judicial practices are or have been so far, and however different judicial attitudes have been shown, there are some general experience about the behavior of judges in emergencies. It is frequently said that courts are usually reluctant to override emergency measures of governments because courts are very reluctant to take responsibility for possible negative consequences of their judicial decisions. Therefore, most often they show deference to the crisis management of the government authorities. Other scholars presume that judicial behavior in a crisis situation changes over time. So at first, why this severity, the extent, and consequences of a specific crisis are unknown. They are rather deferential, while later, as time passing, they act according to increasingly strict standards. So if we move forward to the theoretical issue of the role of the judges in emergencies, it is advisable to clarify the most important arguments for and against judicial review of emergency acts. So let me try to outline maybe the most arguments. First, against judicial review emergency measures. The first usual argument is that we can say in the Schmittian argumentation that basically any future threat cannot be foreseen. So simply we can't know what kind of global or regional crisis will break out. Therefore, we cannot do anything in advance with those crises. So in fact, this is a possible argument against all kinds of judicial review of emergency measure, including the a posteriori, that is ex post facto judicial intervention. The next usual argument is that courts simply do not have sufficient information and expertise. That's why they shouldn't deal with those measures. They shouldn't try to review or override the emergency measures which need political balancing anyway. So crisis management is basic, according to this argument, is basically the business of the executive branch, or most legislative branch, that is political branches, and courts are simply not suited to this because they lack sufficient resources and knowledge to do so. The next one is that judicial proceedings are very slow, extraordinary situations to handle an exigency or an existing crisis, and even the prevention of an imminent danger need rapid and flexible responses, and there is no time to wait for a judicial decision, and so on and so on. Then courts do not have sufficient legitimacy for reviewing emergency actions. This is the very well-known so-called counter-majoritarian difficulty. Courts are unelected bodies, and so political branches which are elected bodies, which have democratic legitimacy, should balance the various interests and values rather than courts. And finally, courts could be over-politicized if they plunge into reviewing or deciding those cases. This argument says that if courts decide on issues that otherwise would belong to the political branches, that is, which require political considerations, then they themselves become political actors. Okay, so let's say the arguments for effective judicial protection or effective judicial review. The first is that future threats and dangers can be standardized. So according to this argument, it is simply not true that we cannot know anything or at all what threats and crises may occur in the future. So this might be true only in extreme, less realistic cases. For example, an attack from the Martians. I've never seen any Martians, but it is not a very realistic argument, maybe. Naturally, it is usually unpredictable. Of course, it is unpredictable in most cases that when, where, and with what intensity a potential emergency will take place. Of course, this amounts to significant uncertainty, but it is not true that the law, which so often applies framework rules or content-neutral procedural norms, is completely unarmed or toothless against future threats. So it is simply not true in this form. Then courts have sufficient expertise to review the constitutionality or legality of emergency measures. So although it is true that courts are not well equipped to manage crisis, but that's not the point here. The real point is that what is the very basic function of courts? Their fundamental function is to protect the constitutional order and fundamental rights in times of emergencies, and they are very well prepared for this function. So it is not the same as reviewing the efficiency and effectiveness of emergency measures, but the real issue, the real question is to provide protection for fundamental rights and constitutional order, and that's what the constitutional and ordinary courts deal with. Almost the same is the next one, or maybe the same argument that courts have sufficient legitimacy to do that. And exceptional power as such is dangerous. To grant exceptional power to the government can be necessary or even indispensable for overcoming threats and crises, but still it is the whole situation is too risky for democracy and the rule of law. Government might be tempted to retain these extended powers, like, unfortunately, there are so many existing examples, for example, in Hungary, where we have had a state of danger for more than 4 years, granting an unlimited power to the government. So the government might be tempted to use these extended powers to perpetuate its own position, to consolidate its own power position, and so on and so on. So extraordinary power is dangerous to constitutional democracy, and judiciary can be maybe the most effective institutional guarantee against this menace. And finally, sometimes it is emphasized that there are some examples of so-called governmental underreach. It can be imagined a case when the government doesn't act properly. That is, it doesn't fulfill its crisis management function or obligations, and in such a situation, the court may enforce it to perform its tasks and duties. I can say that other independent values, okay, I need some time, 10 minutes maybe. Okay, thank you. So I believe that other independent variables can influence the role of courts in times of emergency. This role, at least according to the academic literature, this role can be or is basically influenced by the institutional position of courts vis-a-vis other power branches, where, for example, when or in those countries where the access to courts are severely limited, the role of courts is naturally much smaller than in other countries where ordinary people can reach quite easily the courts. Sometimes emergency decrees have difficulty, so it is quite difficult to reach courts with legal claims against an emergency measure, just because basically a normative act behind the individual actions is attacked or is contested, and sometimes the people, and let's say the courts, should or have to wait for individual measures, individual decisions of administrative authorities, and only against those individual decisions they can turn to the courts, rather than to the normative acts. Okay, and finally, I would say that this role is basically influenced by the political or constitutional nature of a country. I mean that the normal relationship of judiciary with other power branches are quite or fairly distorted in autocratic regimes. Let me have an example from my own country, that's from Hungary. In 2020, gay rights activists wanted to organize a demonstration for protesting against an upcoming, let's say, homophobic constitutional amendment of that time, of those days in Hungary. So against the constitutional amendment which aimed to prohibit the same-sex marriage and the adoption of children by gay couples. Since then, it has been adopted, of course. However, the police banned this demonstration, referring to the general prohibition of the right to assembly at those times, those days. This general ban was introduced by an emergency decree of the Hungarian government under the state of danger declared for first time in March 2020. When the case reached the Hungarian Constitutional Court, so in that case, the Constitutional Court, there was an access by the activists to the Constitutional Court through a so-called constitutional complaint. The court refused the complaint, simply saying that it is a matter of expediency to assess what measures are needed to tackle the health crisis caused by COVID-19 pandemic. So according to the court, this is a governmental task which the court has no power to review at all. So the government, consequently, the government may freely decide whether it bans the gatherings or not. Considering the wider context of the case, it was not only I think, a deferential judicial behavior, but a self-evident consequence of a particular subordination of the court in an autocratic regime. So I wouldn't, certainly in formal sense, it was only a deferential decision of the court, but it was a quite straightforward consequence of the court's position in this autocratic system. So still, it is an open question that what to review. Even if we recognize the role of judiciary in respect of emergency measures, what is the legitimate scope of judicial review? There are several different possible answers to this question. Maybe they can be classified into two groups. But there can be several variations of both. First, the so-called procedural rationality check. It can mean, for example, that the court only examines whether the emergency measure was issued by the authorized body and whether it complied in the decision-making process. It complied with the relevant procedural rules in doing so. So maybe it is the most rudimentary, most simple role of judiciary of a particular court in case of emergency. Another form of procedural check is that when the court examines whether safeguards were built in the process to enable informed decision-making, even by the competent public authority. Procedural rationality check reflects basically, I mean, a deferential or moderate judicial attitude, as compliance with procedural rules is clearly a minimum requirement, a minimum standard of exercising exceptional powers. The other possible answers or group of judicial behaviors or judicial review is so-called substantive rationality review. Sometimes it is called substantive rights review rather than a pure procedural review. And
Zoltán, just to let you know that in 15 minutes I have to empty the room, so we have like 5 more minutes.
Yeah, okay. Just 2 minutes.
Sure, perfect.
Okay, so it might also have different scopes and forms. Pure rationality check, in this case, the competent court examines whether there was a real reason for the rights restriction and whether the restriction was reasonable in principle without going into details of the emergency measures. Another form can be public, so-called public interest review, whether the use of extraordinary measures are or have been justified by real public interest. And finally, an even more extended judicial review applies a proportionality necessity test, which is a very well-known judicial test. It means that the court itself balances between the state interest and the fundamental right. It examines not only whether the rights restriction had a legitimate aim, but also whether the restriction was necessary and suitable for achieving that aim, and whether it was proportionate, or whether a milder limitation of rights would have been sufficient. So it means, and this is my last word, it means that the strongest form of possible judicial review, I would say that it is let's say, evidence-based investigation of rights limitation imposed under emergency power. So conceptually, as I said, it is the most extensive judicial scrutiny. So that's all. Certainly, there are some standards or possible judicial standards. Maybe I can show you. Yeah, these are. There's no, I'm afraid, to talk about those, and it can be also a useful short list of some relevant literature. Anyway, Professor Belov himself wrote about it 2 years ago in a book. Yeah.
In several books, actually. Yeah, I was kind of occupied with the topic of crisis and emergency, so I became kind of prolific. Pouring down my anger into paper.
Okay. Thank you for your attention. Sorry for the time.
No, well, it was a wonderful lecture. I would like to thank, on behalf of the whole audience, Professor Szente. I think it was not only interesting, but also very informative and very well structured. So we have to empty the room in 5 minutes, unfortunately, but still, if somebody has some pressing question to ask, because I have many questions, but unfortunately, it seems that there is a kind of overlap in the schedule of that room. We occupy an incredibly beautiful place we are at the moment. So any questions from the audience? A short one and fast and furious one. I don't see forest of digital hands. So I'm just using the opportunity to thank again to Zoltán for this really, really interesting and unfortunately still topical presentation. And just to announce the topic of the next lecture, which will be part of the Constitutional Imaginaries lecture series. It will take place on the 17th of March, and we will be delighted to host Professor Irzsib Sivan, who was for a long period of time head of the Socio-Legal Studies Institute at the University of Cardiff, UK, and now he is the judge at the Constitutional Court of the Czech Republic. So thank you very much for your attention. Thank you very much, Zolta. It was really, really pleasant to see you again. See you very soon in Lund. And
in Lund, yeah.
Exactly. And all the best to everybody. Yeah. Stay tuned for these project lecture series that are coming like a train in the spring. Thank you very much.
Thank you. Bye-bye.
Bye.